Good afternoon, everyone, and welcome to this FedSoc Forum webinar titled Preemption and Power, the Federal and State Tug of War in Communications Policy. My name is Libby Dickinson, and I'm an Assistant Director with the Federalist Society's practice groups. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. In the interest of time, I'll introduce today's moderator, who will then introduce our impressive panel of legal scholars. But if you'd like to know more about any of our speakers today, you can access their full bios at fedsoc.org. That is fedsoc.org. To that point, our moderator today is Paul Beaudry, Vice President of Regulatory and Corporate Affairs at Breezeline. One last note throughout the panel: if you have any questions for our speakers that pertain to the topic at hand, please submit them through Zoom's Q&A feature, not the chat, so that we'll be able to access them when we get towards the close of our webinar. And with that, I will hand things over to our moderator to start things off. Paul, thank you so much for joining us today and for moderating this excellent panel.
Well, thank you, Libby, for the kind introduction, and thanks to the Federalist Society for hosting this webinar on this very interesting and wide-ranging topic of preemption and the FCC's powers. We've got a top-notch panel of experts to discuss these issues with us today, and maybe before we jump into the crux of the matter, I would appreciate it if each panelist could briefly introduce themselves, who they work for, and briefly state their interest in these issues. So perhaps we can start with Adam first.
Sure. I'm a professor of law at Michigan State University, and I'm currently on leave serving as general counsel at the Federal Communications Commission. I have a great interest in these issues as we are considering several notice of inquiry and a rulemaking, an NPRM, that will address these exact concerns.
Thank you, Adam, and we will talk about these notices soon enough. Next is Morgan.
Hi, yes, I'm Morgan Ratner. Great to be here. I am a partner at Sullivan and Cromwell's office in Washington, D.C., where I'm co-head of our Supreme Court and Appellate practice. I've represented industry groups in a variety of litigation. I'm not here speaking on their behalf, but have been involved in these issues as a litigant.
Thanks, Morgan. And Tony.
Hi, everybody. I'm Tony Clark. I am Executive Director of NARUC, which is the National Association of Regulatory Utility Commissioners. NARUC is the organization that represents the 50 state public utility commissions, along with DC and several of the U.S. territories. We're basically the regulatory officials at the state level. Prior to that, my background is mostly public service. I served about almost 20 years in state government, either as a state legislator in the executive branch and for 12 years as a member of our Public Service Commission. And then for 4.5 years was a commissioner on the Federal Energy Regulatory Commission, or FERC.
Well, thank you, Tony. And maybe we can start with the first theme of this webinar, which is preemption and federalism. And I'd be curious to know from the panel about your thoughts, especially because we are in a Federalist Society webinar, which is kind of a fitting start off for our discussions on how do you view the concept of federal preemption with the Constitution's designed federalism scheme? And how do you think the founders might have intended federal preemption to be exercised? I don't know who wants to take this one first.
Well, I'll go very quickly. It's not going to surprise anyone who, being the executive director of a state association and somebody who spent about 4 times as long in state policy roles as opposed to the federal roles, that in terms of preemption, I'm always often very suspicious of federal preemptory regimes. Now, there are clearly cases where only the federal government can do things, and then there are clearly cases where only the state government can do things, and those are generally laid out. But there are lots of gray areas in that, and there are gray areas in energy law, there are gray areas in communications laws, and that's where the debate happens: is to what degree should preemption take place and what degree not. I mean, generally speaking, under our Federalist scheme, look, there are good reasons why certain things are reserved to the states, and why policy innovation often happens at the states. Often policymakers, as you're dealing with novel issues, you don't know exactly how to address them. And so under the theory of laboratories of democracy, there can be a benefit to having a number of different policy prescriptions tried out at the state level And governments learn from each other about how to do things. We've seen that in lots of areas of law and policy. Switching over to the energy side, I think the sort of how the energy industry was restructured starting about 25 years ago is a really good example of that. There were some policies that stuck and took place and ended up being very beneficial for competition and for consumers. Others, like what happened in the Western US, clearly identified big problems early on. And it's good that there was an allowing of some of those different ideas to flourish, as opposed to just having one regime dictated from Washington, D.C. So obviously the specifics matter, the industry matters, the laws that are at play in terms of federal law and how much authority is granted to each individual commission at the federal level versus the state level all matters. There is some gray area, but it can be very fact specific.
Thanks, Tony. Adam, Morgan, any thoughts on this?
Well, I guess I should come from the other perspective, which is, of course, that states are an essential part of our constitutional structure, and that's what the founders intended. On the other hand, the federal law is supreme law of the land. When there are issues of collective action problems or diversity of jurisdictions that can inhibit important technologies and industries that the whole nation needs, and when there is explicit federal power over these areas, then I think there is a role for federal preemption. Again, as Tony says, we have to be careful, as everything is very fact specific. There are pluses and minuses, but where we have a need to have a set of uniform rules for everybody, particularly in areas of newer and developing technologies of vital interest to the entire country. And when Congress is acting well within its constitutional authority, there's a role for preemption. But again, as Tony says, it has to be fact specific. We have to look for the pluses and minuses, and be very careful as we proceed in these areas.
You're not going to find any disagreement with me, really, with either of you on this, right? I mean, I think we all agree at some level you've got to have preemption consistent with federalism. They're both right there in the Constitution. And the question really is, when did states give up their authority to a federal actor? And I think to the extent you have very strong federalism instincts, then how that comes into play is really in maybe the standard you apply for finding preemption or trying to make sure that this is a really conscious power that Congress has either taken on itself or has delegated to an agency to exercise. But I don't think you'll find any of us disagreeing at the high level of, of course, these two things coexist. And sometimes we think that preemption wins out and sometimes it doesn't.
And maybe as a follow-up, Morgan, to this question, how do you see the administration's philosophy about preemption? And even maybe more importantly, how do you believe the Supreme Court, and in particular the conservative justices, conceive of preemption, and whether you think they're aligned with the White House's views on the matter?
So that's a great question. I mean, the Supreme Court really has not given us a ton of data points on the current Supreme Court on these extremely important issues. I think we've seen a little bit of a shift on the conservative side to making preemption a bit more textually based. So, the basic buckets, field preemption, conflict preemption, express preemption, those are the same now as they once were. But, when I was in law school, we learned conflict preemption was like, does this interfere with the purposes and objectives of Congress? And I don't think the current Supreme Court really applies conflict preemption at that general level. It doesn't think of this sort of abstract appeal to what we're trying to do as a federal government, right? And so it really wants to concretize it to the text and say, show me where there's a real clash between what Congress has done and what the states are trying to do. I think, again, we're still waiting on good data points there. We had a sort of technical banking preemption case 2 terms ago, I think, And other than that, not a whole lot in recent years. We have one case I'm watching on preemption that was recently CVSG'd, or the court called for the views of the Solicitor General. Another case on preemption that's a real contender that's up at the Long Conference, which will be Monday. And so I think we have an opportunity actually this term to get one or two data points on how the current court is really thinking what level of congressional intent it's requiring for these preemptive solutions. As for how that matches up with the administration, maybe I'll defer to Adam on the administration's views on preemption. I guess I would note that this certainly is an apparent priority. I saw yesterday that DOJ announced a new affirmative litigation section within the civil division that is specifically described as in part filing lawsuits and focusing on private entities and states that interfere with federal policies. So, I don't know that the press release said the word preemption, but I'm pretty sure that is the primary concept of states interfering with federal policies. So I think there's definitely interest on the administration side. And the question is, are they putting their arguments in the boxes that are going to best appeal to the Supreme Court?
Adam, did you have anything to add about the administration's philosophy with respect to preemption?
Well, I'm just GC at the FCC. I mean, the high matters of constitutional theory is more of a Solicitor General's and DOJ item. I will just say that yes, I mean the FCC is very much in step with the administration in using preemption to advance the administration's goals.
And if I just may ask you, Adam, so the current thinking in the administration is that the FCC is part of the executive branch rather than being an independent agency. And does that have any legal or practical impact on the FCC's ability to preempt state action?
I don't think so. I think as lawyers, we love to play the parlor game of so-called independent agencies and what that means. It's always been a very sort of ill-defined concept, and I think the president has always had a very strong role in directing what the FCC does. People forget that the FCC chairman, qua chairman, serves at the pleasure of the president. And from my experience, and as someone who's actually studied this empirically, FCC chairmen have always been very, very close to presidents, and we have always been very close to administration goals and priorities.
Can I just jump in on that, Paul? I mean,
yes, please do.
I do think, Adam, at the risk of being a pie in the sky Supreme Court kind of person here, so Justice Kavanaugh wrote separately in the Consumers Research decision, which I know you all are very familiar with. And, one of the things that he said, I do think is, look, maybe the FCC does have more room, not necessarily written in terms of preemption, but in terms of the authority that could be delegated to the commission. And I would assume would include preemptive authority. So I think that you all would say, if you were getting challenges, that you actually have more room to act, or you're less susceptible to non-delegation arguments against you, in part because there is this greater responsibility of the president.
I mean, I'm open to those arguments. I mean, I don't think we've actually come to a precise opinion on that, but I mean, I don't see anything necessarily wrong with what you're saying.
Yeah, at least Justice Kavanaugh made them for you.
That's right, exactly.
And Tony, I did not miss your reference to the states being laboratories of democracy. Maybe just digging a bit onto that sentence. Do you think there are some issues that are best left to the states to regulate in the telecom field?
Oh, sure. And I mean, I would step back and first say I tend to look at these things more as a policy guy because I'm not a lawyer, but I tend to be more practically and policy focused. And oftentimes state commissions are, right? I mean, they're not policy makers for the most part, although they can sometimes stray into that role in their rulemaking function. But for the most part, they're policy implementers. So they tend to look at things from a very pragmatic standpoint. And that's how my association, NARUC, has traditionally looked at these issues in the context of communications. Now, there can be differences in other sectors that we deal with where there may be very strong reservation clauses for state authority. Energy is a pretty good example where states retain a lot of authority vis-a-vis where the trend has been in communications. But what we've always, at least for a long time, advocated for is a sort of collaborative federalism, where you look at things on a case-by-case basis, fact-specific, attempt to adopt and craft rules that make sense for consumers and leverage the institutions of government that are best suited to be able to carry out the policy. And there are certain areas where states have a particular strength and have a long-running activity in that space. Things like universal service. It's always been a shared responsibility between states and the federal government, and we think should be moving forward. There are also reservations clauses and things like public safety, things like that, where there's clearly a direct link to end-use consumers, where there are probably better resources at the state to be able to issue spot certain things in a very granular way, where even if the trend may be more towards federal authority, states can be enlisted to be the boots on the ground in ways that can improve consumer outcomes that just can't be done from one federal agency situated in Washington, D.C.
Thanks, Tony. I think we can pivot to one of the hottest topics right now, which is AI regulation. During the negotiations over the One Big Beautiful Bill, Congress did seriously contemplate, but ultimately refrained from enacting an AI moratorium that would have prevented states and localities from regulating or otherwise limiting AI for 10 years. I'd be curious to hear your thoughts about whether this moratorium was a good idea and whether Congress should revisit it. We can start with Morgan.
Well, I'm probably the least policy focused of the three, so I will defer to the others on the wisdom. I will say, with preemption more generally, it is always true that Congress could swoop in and spell out exactly what is preempted and what isn't, and that'd be great. There are many circumstances where it may not be realistic to expect extremely granular regulation from Congress. And so agencies have to look to the tools they have. And so to me, the critical question is, agencies shouldn't stretch those tools. We've seen some dramatic rejections under, for example, the major questions doctrine. But if agencies have the tools, they will have to work with what they have, even when confronting new policies. So I'll defer to others on the wisdom. I think maybe that's probably not the question as much as what can we do with what we have.
So, I mean, to the specific question about AI, to that, our association hasn't yet taken a specific position on that. So I wouldn't get over our skis. I wouldn't get over my skis on that. But when you take a look at the AI action plan, it's focused on blocking quote unquote burdensome AI regulations. And it also, I think, pretty prudently in the action plan talks about specifically that the federal government or the FCC should not interfere with states' rights to pass prudent laws that don't unduly restrict innovation. So what we would urge, I think, if I was sort of surveying the temperature of states generally, is to take to heart that kind of admonition that there is a balance here. Yes, AI is very important. We want it to take off in a way that allows for innovation. Yet at the same time, we want to make sure that states aren't entirely preempted and that we have sort of specifically tailored policy prescriptions so that states are still allowed to protect consumers, because there are going to be emerging issues in AI, and it's likely that some of those issues and pressure points are probably first going to be identified at the state level. And so allowing for some policy flexibility to allow state action probably makes some sense, and that we should try to not too tightly tie things down so that what happens at the federal government becomes a really, really tight box, both a floor and a ceiling, without any allowance for sort of state innovation.
Yeah, and you mentioned the AI action plan that President Trump announced recently. And Adam, I'd be curious to know, so the action plan requires the FCC to evaluate whether state AI regulations interfere with the agency's ability to carry out its obligations and authorities under the Act. Are you able to provide us with some insight into how the FCC plans to approach this evaluation?
Sure. I mean, I think some of the draft documents that the FCC is considering are now public. And I think that AI plays a role, or at least we've been told. People have come to us and explained the role that AI plays in routing traffic in modern communications networks. And to the degree that state laws regulate AI, they will affect the way communications networks work. And that's something of great interest to the FCC. We are under a statutory obligation to examine state laws that could have the effect of prohibiting the deployment of communications infrastructure. And so that's what we're doing. We're at the asking question stages. As Tony, as Morgan pointed out, these are very complex issues. I think one of the biggest problems with AI regulation is that nobody's quite sure what they're talking about. We have these definitions that are unclear. And we also have, the admonitory example of the EU, where we had a very expansive, I would say, unclear and vaguely written regulation that has had a terrible effect upon the development of these vital technologies within the European Union. So with these sort of considerations, with this statutory authority, we're beginning to examine this question.
Thanks, Adam. And I think I heard Chairman Carr recently say in a political event that the FCC, you guys are the pipes and tubes people, and your role is to ensure that you have the best networks in the world that can enable innovation, including AI innovation. Tony and Morgan, do you have any advice, concerns that the FCC should consider as part of its new mandate? And maybe more for you, Tony, do you see areas of AI policy that would be best left to the states?
Well, so like I said, I mean, NARIC itself hasn't taken specific questions on that, and much as anything, it's because it's complex, as Adam said, it's very complex, and this is all sort of very new. So we're all trying to figure this out together. To the degree that I would counsel anything, I think it would just be that sense of balance that I had talked about before. That's actually contained within the AI action plan itself, which is that yes, let's block burdensome AI regulation so that we don't end up in the sort of EU type situation, while at the same time respecting and understanding the other part of that charge in the AI action plan, which is that the federal government shouldn't interfere with states' rights to pass prudent laws that aren't unduly restrictive. And that's a balance to be struck, but it's a complex one to achieve.
Thanks, Tony. Anything to add, Morgan?
Not much. I'm happy for Adam to figure this out in the first instance and leave it in his very capable hands. I do think some people said to me, like, why is the commission tasked with doing this? And it reminded me sort of to pull up the original mandate from 1934, where one of the policies in creating the commission it's the policy of the United States to encourage the provision of new technologies and services to the public. So this is something that has been kind of within the commission's charge for a long time at that very high level. And then now the devil's in the details, but we'll let Adam take the first crack at those.
Yeah,
Great, sounds good.
I'm sort of afraid. It's sort of like when you ask one of your associates to take a first crack at a brief.
Yeah.
I mean, that's sort of a frightening thing.
I have excellent associates. It's not not worried about that.
Maybe we can pivot away from AI and look at the issue of state regulation of broadband. We have the recent Sixth Circuit decision that invalidates the FCC's 2024 net neutrality order and the 2019 DC Circuit decision in Mozilla that found that the FCC does not have the authority to preempt state regulation of broadband. I'd be curious to hear your thoughts. Maybe we can start with Morgan. And how do we ensure that broadband providers aren't subject to kind of a patchwork of different sets of broadband laws across all 50 states?
Yeah, so I think this is hugely important. I do not think that decisions like Mozilla should be understood to close the door on preemption of broadband regulation. I do think we need to have a bit of a paradigm shift in terms of what is the source of that preemption. And the FCC is a very interesting entity because it has many of these specific preempting authorities, but for many other agencies, we're never talking about the agency choosing to preempt the way that the commission has some preemptive powers. We're usually talking about what Congress did in the statute. And so I think some of the earlier decisions like Mozilla were talking about the agency's choice, the agency saying, okay, we're choosing X and we could choose Y, we're preempting Y. But at bottom, now we know that wasn't really the agency's choice, right? It was Congress's. And so now the way to think about preemption, in my view, is, well, did Congress just not empower the commission to act in this area? Or did it actually want this industry to be free from certain heavy-handed regulations altogether? And so I think that a lot of the case law up to now has really focused on that, like, what can the commission do to preempt angle, and not so much on, did Congress choose to leave this with light touch regulation by everyone? And even in the Sixth Circuit's decision in the Ohio Telecom case, it really takes a Congress-focused view of the statute and says a lot of things that I think carry over to the preemption side as well. It talks about the strong statutory evidence that Congress sought to implement a uniform nationwide policy of a sort of light touch for internet regulation. And so I still think there's more to come. I mean, I think your question is a little bit like, well, if the FCC can't preempt in and of itself, what do we do? And I think the answer is, well, let's talk more fundamentally of, did Congress preempt states here? And I think there are arguments to really think about on express preemption, conflict preemption, and field preemption, and in particular, viewing those in that kind of text-oriented way that we talked about at the start of the hour.
Thanks, Morgan. And maybe we can migrate. So Adam, I had a question for you about the recent Second Circuit decision that was issued on the New York State affordable broadband legislation, which does require broadband providers to offer low-cost broadband programs. And I'm curious to know if you think the FCC has any power to prevent states from engaging in this type of broadband regulation, and especially rate regulation.
Right. Well, I mean, I think I'll piggyback on, I think, Morgan's, very insightful comments. This is a very legally complex area where we have a bunch of opinions going on in different ways on different parts of the act itself. An act which is, Justice Scalia famously said, is not a model of clarity. So I think, the FCC is eager to pursue its authority to, create and to further, I think, congressional intent in this area, but it's a difficult thing. And we certainly understand the difficulty that carriers face when they are essentially required to provide service under, what could uncharitably be termed as confiscatory rates. Whether or not we have the statutory ability to do that, whether the courts will give the FCC the ability to do that, whether there's good legal theory, we're all ears, very sympathetic to some degree. But again, we can only act within our lawful powers.
And maybe if I can finish on this topic with Tony, who's the state person, if I may call you as such. What should the states be empowered to do? Should they be empowered to adopt low-cost broadband programs for low-income residents? And do you see benefits in allowing states to enact individual laws that govern broadband more generally?
Sure. So NARUC as an association has long endorsed and is on record as endorsing a federal program to support low-income consumers. But for probably pretty obvious reasons, we tend to rarely take positions that would dictate or suggest to our own members, our own states, specific public policies that we think they should adopt, that we really leave it up to individual states to make those calls. And in this area, some may support and some probably wouldn't adopt. But as a general federalism principle, as I indicated earlier, NARUC does tend to endorse and support an allowance for some state freedom to try different policy prescriptions that might work for the residents of their states. And so generally supports state experimentation as an allowance, even while not necessarily endorsing any one particular way of going about it. And if this is allowed to happen, then other state policymakers can evaluate the types of impacts that different state approaches are having, and might be able to better assess things like, is it really getting at the low-income access problem, or are there other issues and problems that arise? And those state prescriptions that work can be copied, and those that don't won't be copied.
And Tony, I'm curious, do you see, in addition to the states playing a role, can you see a role for local franchising authorities, or does it stop at the state level?
I don't know that we've probably ever really done a deep dive on that particular issue. I mean, we, as an association, we, clearly states and state regulatory commissions are kind of our bailiwick, but I don't know if we've ever delved into that topic.
And Paul, can I just add,
Yes,
this is not something that is specific to this issue or to the FCC, right? This is something that we've seen in a variety of areas in a post-Chevron world, where you narrow the federal agency's sort of field of operation, and then you have to figure out what happens. Do states get to rush in and fill the void? Did Congress just mean for that federal actor to do less? Or did Congress mean for that industry or that area to be less regulated? And states can't rush and fill in the void either. And so that, I think, is the fundamental question here, but it is a question that we are seeing arise in a variety of areas as a consequence, I think, of getting rid of the Chevron doctrine.
Thanks for that. Maybe let's go now to permitting. So maybe I'll start with you, Adam. The FCC recently released public drafts of a notice of inquiry on wireline permitting reform and an NPRM on additional wireless permitting reform as well. And both of these are going to be considered at, I think, this coming Tuesday's FCC open meeting. Can you tell us more about what's the FCC looking to achieve in these proceedings?
Sure. Well, this is part of Chairman Carr's Build America agenda. He has brought new spectrum to auction, which, after the Biden hiatus has not been done for many years. He's looking to totally revamp our satellite regulation to allow speedier use of space resources and development of technologies there. And we're looking at cutting red tape and lowering the costs of deploying wireless technologies and other communications infrastructure. And permitting reform, right-of-way reform is part of that. We're taking another look to see what will be the best way to ensure that we continue to drive American industry and development, and also to see how our authority, which has been upheld, but how it can be applied in new ways.
Well, I can say that as a cable operator executive, like we're very pleased at Breezeline to see that the FCC is turning its attention to these issues, particularly with respect to wireline deployment, considering that we have experienced delays in securing permit requests and have had to assume costs that we don't think are tied to a locality's actual cost when it processes permits. So we're very encouraged by what the FCC is doing. I was wondering.
Please submit comments then. We're very interested in your views.
We will. In 2018, so when the FCC took action on the wireless side to adopt shot clocks and cost-based fees for small cells, we're kind of wondering, does the FCC have a similar authority to place similar limitations on wireline deployment?
I think 253 does give us that authority. And we've already used it in other circumstances. And the statute says that we have preemptive power over state laws and regulations that prohibit or have the effect of prohibiting the deployment of infrastructure. And if you look at certain permitting practices, refusals to permit, unreasonable delays, or potentially, high enough prices, that can have a, in effect, result of prohibiting the deployment of valued infrastructure that would be benefits to everybody. So again, we don't have firm conclusions here. We're just asking questions at this point. But we believe that Congress at least gave us this general area to look into, and that's what we're doing.
Tony and Morgan, any thoughts on this?
Sure. I mean, I think this is the overarching sort of theme or premise that I started with is, well, a lot of the question for preemption is, did Congress make this choice, right? We know it can make this choice, did it? And here it really did in 253 give broad authority to the commission. It could have said just that it has regulatory authority when there is a law that prohibits. But instead it adds prohibits or has the effect of prohibiting, and that's got to widen the lens, right? That's got to widen the scope of what the commission can do and what it should take a look at doing. And so I think a lot of these, we talked at the start about, kind of going piece by piece. It's fact specific or issue specific. And I think here you have statutory language that is meant to broaden. And then the question is sort of like, how far does that broadening allow? And I suspect that there will be continued discussion on that down the road.
Yeah, I think that's right. I mean, so I would say that state policymakers, just like our colleagues at the federal level, are always on the alert for try to look for ways that we can streamline regulatory processes, including permitting. I mean, these are issues that affect states as well as the federal government, so we're keenly aware of that. We also aware there needs to be a proper balance. NARUC, this is another one of those, we don't have an official position on whether additional FCC action is warranted in this area, but as Morgan said, look, the broadness and the breadth of the authority that the FCC has under 253 is something that will probably be tested, and it will raise questions that may get hashed out in the courts.
And do you think, so Morgan, you touched upon the power that Congress gave to the FCC pursuant to 253, but do you have any other thoughts about that, the role that Congress should play in permitting reform, and to what extent should Congress be looking at exercising its preemption authority?
So you asked about AI before, what could Congress do? I was maybe a little skeptical, but there at least, Congress hasn't touched this. To me, Congress has thought about at least this area and has given the FCC a broad authority. And so whether it needs to come in and do more may depend on whether it's perceiving the FCC as acting enough with the authority, with the tools it has already given it, or whether it perceives courts as reining in the FCC when the commission is using tools that were appropriately given to it. So to me, this is I don't know that this is an area that is realistically going to cry out enough that we get some congressional attention, but maybe others will have better insight into that.
Any thoughts from others? We can go to the next topic, which is another area where preemption might have an interesting application, which is privacy. Maybe I can start with you, Tony. So Congress has not yet enacted a comprehensive federal privacy statute. So maybe you can start by discussing the role that states are playing and have played in protecting consumers' privacy rights.
Sure. I guess I'd answer it in kind of two ways. One is more specifically to the members of my association, which is state utility regulators, public service commissions, and the like. In general, state commissions don't tend to play a big role in most of the big privacy issues that I think we talk about, generally speaking. Now, to the degree that there are privacy protections and debates and issues that come in front of state commissions, it tends to be in the context of very sector-specific kind of issues, right? Where it's a utility sector-specific thing, and it's what can you do with the customer's, proprietary information, and that information, how much of it can come before a state commission in a regulatory proceeding, and what's protected, and things like that. So it tends to be like our activity tends to be most tightly focused on that. Generally speaking, at the state level, there are oftentimes general sort of state privacy statutes. Those tend to fall under the purview of our state's attorneys general, and they'll either take enforcement action, and sometimes either in place of or in conjunction with, in some cases, the FTC. That tends to sort of fall outside of our wheelhouse of activity. But at the state level, privacy protections have tended to be more of an AG thing, generally speaking, and where state commissions and regulators get involved is in the specific industries where there may be some reason that the industry is appearing before our commission or has very specific customer data under a kind of regulated environment.
And maybe on this, I'd love to hear your thoughts, Morgan, on the prospects of a federal privacy statute being adopted at some point. And I'm curious about the prospects of this happening, but also to the extent Congress eventually does pass a federal privacy statute, what does that mean for all the pre-existing state privacy regulations that are on the books?
Yeah, so I have a completely non-data driven gut reaction to this, which is when you're talking about both preemption specifically and federal government involvement in an area more generally, there's kind of like a sweet spot where like some troublemaking states start doing some things that make it feel like a patchwork, and then there is an impetus to intervene at that point, right? Either by litigation saying, look, Congress has already said this is not an issue for states, or legislative reform, where Congress itself says, well, we didn't say that before, but we are now saying this is not an issue for states. And if you sort of wait too long to have that debate, then I think over time it can start to look like, well, maybe the states are sorting this out, and the incentive or the urgency for Congress to get involved maybe feels a little lower. So I don't know if, we probably have 20 some states with comprehensive consumer privacy schemes. I don't know where we are on the tipping point, but it's hard for me to project whether there's going to be action in the future if states continue to adopt these things and the problem feels more or less, handled at the state level versus just a couple early outlier states. And it feels like some sort of federal action, federal preemption kind of nips it in the bud. I don't know if Congress does act to, where they will send that. This is maybe one I'm very supportive of the commission's authority in a lot of areas. I'm not sure that consumer privacy is the commission's wheelhouse as much as, for example, the FTC. So I don't know exactly what we'd see out of Congress if it acts on this front. So I can't say that I think it's overly likely that we'll see something soon, but I think a lot of it is going to involve that how things are going at the state level. Does it seem handled, or does it seem like it's getting more and more of a patchwork and untenable for business?
Yeah, I can say we have operations in 13 states, mostly on the East Coast, and the patchwork of different legislation, and that sometimes differs significantly from one state to another, can be quite onerous, especially for smaller and regional carriers who don't have the biggest compliance departments to look after all of these laws. But who knows, maybe one day we will get federal legislation. Maybe a question for you, Adam. So the FCC does have a certain level of authority on privacy matters in Section 222 that governs telecom providers' use of customer proprietary network information. But do you see, any additional role that the FCC could play in the future with respect to privacy?
Well, possibly, but as Morgan points out, it's not our primary wheelhouse. We do have some authority. It's just that Section 222, CPNI. There's also actually some cable privacy rules, rarely enforced. But we tend to stick to the authority that Congress gives us, and we have really rather specific requirements, specific obligations. So I would be surprised. One point I would make, there is one non-state actor whose privacy rules have a huge effect, and that, of course, is the EU. I think there perhaps is a possibility that this administration might want to react against that, because for better or for worse, Brussels is regulating a lot of our businesses through its sort of the Brussels effect on global industries. So that's something to consider as well.
Thanks, Adam. Maybe we're getting close to the end of our webinar. Just maybe an open-ended question to all of you. While we're thinking about the future, what should we be watching for in the preemption space? How do you think Congress is going to approach these issues? Are they going to be a bit more active in the area, or less inclined to preempt state action, or even potentially giving agencies more authority to preempt? What do you anticipate might be what's coming on the area of preemption?
Yeah, I don't, I'd take a step back just from communications for a moment, because I think it fits as part of a broader picture, and it's not entirely clear yet, because there are some mixed signals that I think those of us who are trying to read the tea leaves in Washington, D.C. sometimes are receiving. So on one hand, I think the general push of the Trump administration is, let's reduce the size and scope of the federal government, the federal bureaucracy, federal regulations, which is sort of traditional conservative, sort of policy prescriptions that you would expect from a Trump administration. At the same time, in certain of the EOs, some of them in this space that we've talked about, some in the space of energy, which I track a lot, also have other clauses that talk about reviewing state policies, laws, and regulations for, subject to potential litigation that the federal government would bring against the state, which sounds very preemptory and maybe surprising from given sort of traditional politics. The bottom line is that we're not going to know until we actually start seeing individual actions taken. The executive orders themselves, the general policy direction clearly comes from the White House, but it's individual agencies acting within their authority that carry those out. And it's going to be, very dependent, getting back to our initial discussion in this area, it's going to be very dependent on the laws under which they act. I mean, certain federal laws give a lot more runway to certain federal agencies in particular areas than do others where there's very strong reservation clause for state prescription. So I assume that to the degree those EOs are being combed through at the executive level, and I'm sure they are, they're doing so with an eye towards that there will be certain areas, certain agencies that just have more authority at the federal level, and you probably will see more executive authority in terms of preemptory policy there. And then probably an analysis made that in other areas, there just isn't the legal sort of standing to be able to go forward with some of the more preemptory things that people are talking about.
I mean, I think we are going to see more preemption fights across the board. We're going to see more preemption discussion out of Congress when they discuss things. We're going to see more affirmative government preemption litigation. We're going to see more preemption cases getting to the Supreme Court. And I think all of this is a product of really what I said before, which is there's been a project for some time of reining in the excesses of the federal government. And now the question has become, well, did that backfire if every time you pulled back what various federal agencies could do, in its place came an even more aggressive state? And the fact that because the federal agency can't do a little more, now, states typically on the more political extremes, one way or the other, are going to start doing something, right? And so the question in boardrooms across the country is, like, in fighting all that federal regulation, like, did we just shoot ourselves in the foot? Like, is it just that was all for nothing, and now we're getting regulated by California instead of by a sort of aggressive federal agency? And so obviously, as Tony said, how those specific fights come out will be case dependent. But I think the general theme of seeing more preemption litigation or preemption discussion out of an administration that is concerned about federal overreach is actually consistent for that very reason. Because otherwise, if you don't have that preemption angle, you just sort of undone everything that you worked for.
Yeah, I mean, I think I would echo Tony and Morgan. Certainly, this administration will be using preemption authority to the degree it has it to forward its goals, and primarily from our perspective, the FCC is to help foster innovation and development of communications technologies. And this is when the rubber hits the road, and the FCC is involved in a careful evaluation of our powers. And whether or not state laws are of the type that Congress intended to preempt, and which actually do pose a potential or real threat to the American economy.
Thank you for this. We have a bit of time for questions. I have one question in the chat box, and I've got one that's a bit long, and I'm too lazy to paraphrase, so I will say it out loud. Regarding the desirability, at least from the perspective of well-capitalized incumbent firms, of uniform standards across all states, why aren't mechanisms like inter or multi-state compacts and uniform law tools that better reflect federalism, state authority, and the laboratories of democracy principle than express or worse dormant commerce clause federal preemption?
It sounds like a law review. It sounds like a law
Yes.
final. So exactly.
That one should be published, but
Yeah, that's
sorry.
right.
I hope you got the theme. If
I'm
you
gonna
have
use
any
that. I'm
thoughts
gonna use
about
that my
that
next
theme.
ad law exam. So
Any thoughts on this question?
Yeah,
well,
I think
oh, please,
right.
please,
And
Tony.
yeah, having served in a state legislature, from time to time, legislatures do talk about things like multi-state compacts, and there are some out there. And I think in theory are attractive to a lot of state officials. The challenges are very tough to pull together from a practical standpoint, which is probably why you just haven't seen them flourishing. But the question is a good one. I mean, it is a tool that's available and out there, and and who knows, maybe you'll see more of them. But as a practical matter, they are tough to pull together.
Yeah, the typical law and economics approach is, why do we have enumerated federal powers? It's because the states face collective action problems in solving these problems on their own. So in many ways, state compacts are a wonderful idea, but as Tony points out, they have a lot of transaction costs, and I think that's one of the reasons why we don't see them as often. But as a theoretical matter, I think they're a great idea.
Libby, I don't know if there's any other questions that you've received. There's none other in the chat. We have about 5 minutes left. I just had one last question that I want to ask the panel. So we've made this a little bit adversarial. Should the federal preempt the states? What should the states do? Should they be free to legislate how they want? Is there kind of a middle ground scenario where actually the two can work together and the FCC can actually play a role in bolstering whatever the states can do to enhance and encourage the viable deployment of broadband? Curious to know if you have any thoughts on this one.
Oh, sure. I mean, and back to some comments that I've made along the way. I mean, cooperative federalism is a core principle that NARUC and state commissions have supported for a long time. And I mean, beyond just state commissions, I think that you've seen good cooperation between the FCC and states in a whole host of areas, and things like trying to figure out where broadband is and isn't, and mapping and things like that. There just sometimes is required to be a certain level of coordination and interaction between the federal government and states, who often have better granular data to inform FCC decisions. Universal service, as I said earlier, is an area that traditionally has had some shared responsibility, and is in the statute envisioned to have some shared responsibility. So I think that there are plenty of those areas, and maybe the title, while it's provocative and great, and it's been a great discussion, might sort of set up an either-or situation. Maybe more accurate, there is cooperation that I think happens at each level of government.
We're all in the same team, as Chairman Carr likes to remind us, and certainly, something the FCC is very desirous and eager to do is to come up with solutions, cooperatively with the states, and I think there's potential here for that, certainly.
And the commission has historically, right? It's not all sticks. There have been many carrots, and the carrots have worked sometimes, and sometimes you need the sticks. And I think it's just tough for us to say in the abstract, issue dependent.
Well, excellent. Well, thank you very much. I don't see any more questions, so barring any last calls, I'm happy to turn things over to you, Libby, to close things out.
Sounds great. Thank you all so much to our speakers for joining us today and for sharing your insights. Thank you to Paul for moderating this wonderful conversation. If anyone in our audience is interested in learning more about all of our programming here at the Federalist Society, please visit our website, as mentioned before, fedsoc.org, or feel free to send us your feedback. We always love to hear it at fedsocforums@fedsoc.org. Thank you so much.